The criminal records of all South Australians can now be kept secret following a legal crackdown. It means politicians like Labor MP Tom Koutsantonis may be able to keep the public in the dark about their police records.
When the full extent of Tom Koutsantonis' shocking driving record was exposed, he eventually came clean on 60 road traffic infringements and was forced to resign as Road Safety Minister. Public scrutiny was possible because for at least the previous 2 decades, a person's court record has been deemed to be on the public record. When, in the wake of the Koutsantonis affair, the police records of all other serving Labor MPs were sought, Chief Magistrate Liz Bolton put her foot down. It's understood she's uncovered a memo from a former Chief Magistrate in the 1990s which ordered that criminal histories be made available to the public and the media only with the approval of a magistrate. Ms Bolton has now reinforced that ruling, effectively blocking public access. A person's record does not fall under the type of information that can be released. The court's newfound blanket of secrecy means never again will an MP or anyone in public life be unexpectedly embarrassed by the disclosure of their previously secret run-ins with the law. We simply won't know about it.
How could they be held accountable?
But we will now never know whether any of our politicians have a criminal record.
We won't know whether any politicians have criminal records. We won't know whether any of our legal people have criminal records. And when we see sentences handed down by the courts, we won't be able to make any sense of them. We won't know whether they're fair or unfair because we won't know the very basic facts on which they're based.
And not to mention what it would do for investigative journalism.
Well, it would make investigative journalism in this area almost impossible.
But just hours before the legal crackdown, 7 News obtained the criminal history of a Finks bikie member who's been slapped with the state's first control order. He has no serious convictions, and why he's been singled out first remains unclear.
Finks gang member Donald Hudson is legally under police control. Police now have the power to ban him from contacting certain people and visiting specific places. But Hudson was in the dark when the control order went through the courts.
Fairness would dictate you get a chance to say something to the court. The police are allowed to use secret, untested evidence.
The magistrate has no choice but to grant the order if police prove the person's a member of the Finks.
That's using the judiciary for political purposes.
Why Hudson is the first Fink to cop a control order isn't clear, and he only has a short list of minor criminal convictions. Hudson has had 2 parking fines this year. In December last year, a minor traffic offence. He was also convicted of cannabis possession twice in that year, and there are more traffic offences in 2006 and 2003. The government wouldn't elaborate.
No, I don't, except to say it is an operational matter.
7 News understands police are expected to make several more control order applications in the Magistrates Court against other Finks Club members tomorrow.
Hudson has 14 days to appeal.